Tonight about, as you know, knowing your legal rights, practical guidance to respond to law enforcement, regulatory, and institutional investigations. You can overcome these situations, that individuals do have the power to fight and assert their rights. And again, I mentioned that the adversarial nature of this situation, of our system, is something I want to emphasize to you tonight. In order to persevere as the individual, you have to understand it's an adversarial situation, and you have to stand up for your rights and use your rights to the best of your ability to protect yourself. But by asserting your rights, you can slow or stop a criminal investigation, and people do have success doing that. You can by standing up and figuring out the right ways to communicate, correct false assumptions that prosecutors may have, inaccurate facts that law enforcement has, or misperceptions. You can convince them that one is actually innocent and that the prosecutor should exercise discretion and not proceed. You can convince them that it's not a criminal case at all, that it's not right for criminal charges. Instead, there should be a regulatory proceeding, an alternative civil proceeding that ends up with a monetary fine and not jail time as an outcome. Or you can turn what might be a felony into a misdemeanor. That is, instead of a year or more in jail that one might be facing less than a year in jail. Oftentimes, when one is prosecuted for a misdemeanor, they end up with probation. Or you can convince a prosecutor sometimes that a deferred prosecution is the outcome. That is, you sign an agreement that if you stay out of trouble for potentially, let's say, 6 months or a year, that the prosecutors at the end of that time will choose to drop the case entirely. And so these are these investigations, these can be life-changing decisions. And so that's why I think it's important for you to assert your rights, to know what those rights are, to be ready to stand up for yourselves in an adversarial system. I'm going to talk more about some specific examples, but I'll give you one. I represented an individual, one of 4 brothers, in an investigation where they were being investigated for stealing confidential information about a company and sharing it. That one who was on the board stole that information, shared it with the other 3 brothers, and used that information so that they could trade and make money in the stock market. So they were all visited simultaneously at 7 a.m. one morning by FBI agents, and they all had a choice. Do they assert their rights that they want to speak to a lawyer, or do one of them or all of them talk? And each one of them doesn't know what the other brother's saying because they're not being given the opportunity to talk to one another. They're all being spoken to by the agents simultaneously. And the agents, as I'm going to talk later, the agents are allowed to lie, and they do. One turns to one of the brothers and says, "Your other brother has already told the truth, that you guys stole this information. And you should tell the truth too and come clean and protect yourself and save yourself. This is your one chance." And that brother at that time said, "No, I want a lawyer. I'm not going to talk to you." Well, it turned out the agents were lying. The other brother hadn't spoken up. But they're allowed to do that in our adversarial system. And in the end, because none of the 4 brothers talked that morning, the criminal case never happened. These people went from facing potential jail time and changing to their lives to being able to walk away with a criminal case that was entirely dropped because they asserted their rights and decided not to speak. And so you need to know that in these kind of emergency situations, you need to carefully weigh what the right decision is. And you need to know that the people on the other side are not looking out for your rights. They're your adversaries. They're looking out for their own jobs, their own goals. So now let's turn to an interview from the University Employer Council or other investigators. So there are situations where a university or a company employer decides that they want to investigate the activities of their employees. And this is done because the employer gets information that there may be wrongdoing going on at their company. It could be sexual harassment. It could be theft of client money. It could be misuse of the company's or the university's tools or resources. There's all sorts of reasons that an employer will want to investigate. And so they carry out that investigation either by having internal people come and interview their employees and look over records such as emails of their employees, or by bringing in outside attorneys, someone like me, to come and do an investigation for the company and try to figure out what's going on. And so how can that come to light for you? You may get a phone call that someone from the university or your employer wants to speak with you, that a lawyer from the attorney's office, the in-house counsel, wants to interview you. So key point number one, as I said before, this is an adversarial system. The university, the company's attorneys, they are not your personal counsel. They're the attorneys for the company, and they're representing only the interests of the company. They're not representing your own interests. Now, sometimes those interests will coincide. Perhaps there's some incorrect assumption being made by the government or by somebody on the outside, or that perhaps a frivolous allegation has been made, and both the university and you know that it's frivolous and want to explain why it's wrong, and you'll be motivated to work together to prove that the allegation is false or to clarify the misconception. But other times, the university employer are in conflict with the employee. And so the number one piece of advice is for you to be getting your own lawyer. You need to hire someone who has experience in investigations, someone who's a former federal prosecutor, a former state prosecutor, someone with white-collar experience, who can help guide you through the system. What are they going to do? You're going to consult with your attorney to determine whether you want to attend such an interview. What you want to do with that person is go over the full history of what the subject of the interview is about. You're going to want to collect historical documents, your emails, your calendar entries, notes, contracts, disclosures you've made. And you want to determine based on that information whether you want to go forward and participate in that investigation. So you have a right to say no to your employer. I do not want to show up for your investigation. And that may be the smartest decision. Now, that could get you fired, and so you need to know that going in. But if telling the truth is going to get you fired, or telling the truth is going to create a bad record for you, there may be very good reasons to decline to participate. You also have to know that if you go into that interview, what's going to happen is the university is going to take notes. The attorney, the compliance person, the investigator, or the outside attorney are going to take notes of everything you say in that interview. And those notes don't stay internal to the company or university. You have to assume that those notes could, if appropriate, if there's a reason, ultimately be shared with law enforcement agents, with prosecutors, with regulators, with people from the outside. And so if those notes follow you, and if it's determined that something you said in that meeting or something they've written down that they've understood wrongly contradicts something you say in the future, you may in the future have to answer for why there's a contradiction. If you decide to go to that meeting, one of the other important considerations is whether you bring your personal counsel with you to that meeting, whether the university will allow you to bring that personal attorney to the meeting. It's important, and I usually recommend it to my own clients, that the personal counsel comes along, because that person takes notes on behalf of the employee so that the employee has a record of what he or she has said in the meeting. The university, they're going to have a record of what they understand you to say at the meeting, but sometimes they misunderstand, but you want your own record of what is said at the meeting. You also, as I've talked about, want to prepare thoroughly for that meeting by going over the history of the documents and trying to understand all the questions that might be asked so that you've thought about those questions in advance so you can answer them in the course of that interview. So some cautions here. As I said before, the university counsel is not your personal attorney. That counsel is looking out for the interests of the institution, not your personal interests. As I've said, again, this is an adversarial system. The university may say, because you're an employee and this is a confidential interview for purposes of them getting information for making legal decisions, that it's a privileged conversation, and they may advise you that because it's a privileged conversation, they don't want you to share the information that happens in this interview with anybody outside. That way the interview stays secret and attorney-client privilege. What do I mean by that? An attorney-client privilege conversation is a communication between a person and their attorney. It could be an employer and the attorney for their company. It could be a person and their private attorney. That's confidential. That is, just includes the person and their attorney, the employee and the company attorney, or the individual and his outside attorney. No third parties. And that is intended to provide legal information, to gain or understand legal advice. But it's important to know that the university owns that attorney-client privilege communication in the context of a company or university interview. That privilege belongs to the company, the employer. It doesn't belong to you. And the university can waive that privilege and decide to reveal that conversation that was otherwise privileged and confidential to regulators or law enforcement if they decide it's in their interest to do so. And ultimately, they can get cooperation credit from law enforcement or regulators by just agreeing to waive the privilege and sharing that information. So you should understand that while the conversation may be a privileged one between you and the company employer as an employee, and they've told you to keep it secret, they can decide not to keep it secret in the future and reveal that information. One of the tools of law enforcement is the surprise interview. At 6:30 a.m. Or 7 p.m. after work, they'll come knock at the door. They'll try to catch people before they're off to the gym. They'll try to catch people at night when they're first home from work. They might stop somebody as they're heading out to grab lunch. Anything they can do to initiate a conversation when the target, the person being interviewed, is not expecting it. And they use this to obtain information when the person doesn't have time to prepare, doesn't have somebody else to sit by them and help them through the process, and that they can then get information out of you. There's a lot of risks to agreeing to interview in that situation. What are those risks? Well, one, the agents are taking notes. They may not understand all the points you are making. If it's a technical conversation, they may not understand all the technical details. And so they can get it wrong. They're taking notes. Those notes, just like the university situation notes, follow you, but those notes can be wrong. Two, there's no one taking notes on behalf of you, the person being interviewed. You don't get your own copy of the notes. You can't both talk to them and take notes simultaneously. And so there's no one making a record of what goes on in that meeting for you. And if there are mistakes that you make or misunderstandings that come up in that conversation, the government may construe that as an intentional false statement. That is that you have something to hide, and so you are lying to them. And in this context, it's a felony to make a materially false statement to an agent in the course of an investigation. So if one were to lie or be perceived to lie, that can end up being a new and different crime of false statements. Headlines. So what's the recommended response? One, politely decline the interview in order to speak with your personal lawyer. You want to say, I'd like a business card so my lawyer can contact you later. I want to talk to my lawyer. I want to follow up with him or her before I speak to you. Please give me your card and we'll do this another time. One of the other things to do in this situation might be to actually record the interaction. So on the M&M Defend app and on lots of phones, you have the audio recording ability. And by pressing that audio record button, you can record these interactions with law enforcement. And so you have a record for your side on how to protect on what went on in that conversation in order to protect yourself. Follow-up. So you've said to them, look, please, I'll take your business card. I don't want to talk to you right now. My lawyer will get back to you and make an appointment. You don't have to have a lawyer lined up at that very moment to say that. You can say, I'm going to get a lawyer and get back in touch with you. And at that point, you should select an appropriate attorney who has experience in this realm, someone who is experienced in white-collar criminal defense. That lawyer will then reach out to the agent to determine what it is they want to interview you about, the areas of law enforcement interest, and to help prepare you and determine whether, just like with the university company interview, whether you want to be interviewed at all, and if so, prepare you for that interview. So what's that process? You'll want to pull and study your email and text messages, your notes, your calendar entries, contracts, disclosures, financial records, tax filings, whatever it might be relevant, to be comprehensively immersed in the background so that you're ready to answer questions if you decide to go forward. And if you decide to go forward, you're going to want to bring that personal counsel with you to participate in that interview. That person can take notes on your behalf and can defend you if they try to pressure you in the course of that interview. Or you may ultimately decide you don't want to be interviewed. You have a right under the United States Constitution, whether you're a citizen or non-citizen, to say, I am not interested in being interviewed and speaking to the government, and I pass. And you are allowed to do that. And certainly I have situations in which I recommend that to the client. And without being interviewed, I think it's been essential to helping those cases go away. Why are these steps and processes important? One, the game is rigged here in the United States. The agents who come to your door at 6:30 a.m. are not doing so because they just think it's a convenient time to talk with you. They're doing so because they're trained to get information from you and getting you when you're not ready. Instead of making an appointment and saying, please come to my office, they show up at your house because they want to get information from you in a way that you're not prepared for. For example, an agent may say when they come to that door and you say, look, I want to get my lawyer and talk to you another time. They may say, look, we only have a few questions. But once they begin talking to you, it's never just a few questions. They've prepared for this interview with a long list of questions. And they can always say to you, anytime you say, is this going to be over soon? I only have a few more. But they don't only have a few more. They'll continue asking questions as long as you continue answering. They may say, can we come inside? You don't want to look like you're being questioned by law enforcement on the front door of your home. Can I come in? And once they come into your house, it's difficult to make them leave. These are trained law enforcement agents. They're often big people. Sometimes they're carrying guns, often. And so you may want to ask them to leave. And they're going to try to convince you to let them stay. And once they're in the house, it's more difficult. They're also allowed to lie. They don't have to be truthful in the course of this interview. So they can say to you, for example, if you cooperate with me, it will go easier on you. But in truth, they lack the ability to go easier on the defendant. That's up to the prosecutors to decide whether to go easier on somebody in the course of an investigation. So what's going on here? The agents are trained with techniques to overcome the individual's caution. They're here to take advantage of the lack of knowledge of the individual about what the rules are in order to obtain information to which they're only getting on your agreement that they're not necessarily entitled to. Let me talk to one other misconception people have. People often hear of Miranda warnings in the U.S. legal system. That is where police on TV will say you have the right to remain silent. Everything you say can be used against you. And sometimes people think, if I am not given a Miranda warning, then the police cannot use the information against me. So they didn't Mirandize me, and therefore I can answer questions, and this will be off the record. Well, one, there is no off the record. Anything you ever say to these agents, whether it's on the phone or in person, is going to be written down and is going to be used against you if they can. There is no off the record. And two, these Miranda warnings don't apply in non-custodial interrogation settings. What do I mean by that? They have to give Miranda warnings when someone's been arrested, when someone's not free to leave. That's what the Supreme Court has said in their Miranda decisions. But at someone's house, you can say, look, I don't want to talk anymore, and shut the door. You can say, it's time for you to go. I want to get my lawyer. You're free to walk out the door and leave them sitting at your kitchen table, in theory. So there's no requirement that they give you Miranda warnings before questioning you in that scenario. So look, these situations are important. These are adversarial. The agents are permitted to lie, and the lying matters. And I say up here at the very top of this slide, it's known to lead to false confessions. That is, a law enforcement agent may say to somebody, you had her blood on your hands, therefore you killed her. And the person thinks to themselves, I don't remember killing anybody. I can't imagine having blood on my hands. But if the agent says I did, it must be true. Maybe I blacked out and therefore that's why I have blood on my hands. They wouldn't lie to me about something this serious. And then the person imagines how it could have happened and they confess. And so there are people who give false confessions because they believe the authority of the law enforcement agents when those law enforcement agents stand up and say, you need to tell me this information, and I'm telling you the truth. And in fact, they're not always telling the truth, and it can lead to bad repercussions. So there's risks in interacting with law enforcement. They can decide that you're lying. As a result, they can try to seek leverage against you, saying, now, not only did you commit whatever crime we think you committed in the first place that we're investigating, we think you've lied to us, and that unless you cooperate with us, we're going to charge you with false statements. Similarly, based on what you say, they may try to broaden their investigation of you or your employer. And generally, it's most important to know that the government has essentially unlimited resources. If the government starts an investigation, it is unfortunately not an equal playing field. People are and can be financially ruined by attempting to defend against the government. And it ends in situations where people will sometimes settle cases or plead to lesser charges rather than engage in financially ruinous litigation with the government and try to clear their name. And so if you can cut off these situations in the beginning by asserting your rights, by understanding this is adversarial and refusing to interact with law enforcement in the first place, deciding you don't want to answer their questions, you're not going to turn over your documents. In appropriate cases, that can be the difference between being able to continue on your way and having a life-changing scenario go forward. Let's turn to the search warrant situation. So the government can obtain a search warrant, that is a document from a court, to search a home, office, a lab, a computer, a closed case. It could be a safety deposit box. It could be an off-site storage unit. It could be a trailer. It could be the trunk of a car. They can get a search warrant to search any sort of place. What's the standard? They need to go to a court and show that there's probable cause to believe that there's evidence of criminal activity, of specific criminal activity, that will likely be found at a particular location. And when they can show the judge that there's probable cause to believe that there's evidence of a criminal activity at a particular location, they then obtain a search warrant, which gives them permission to search and seize specified materials related to that particular crime from a home, office, lab, computer, cell phones, etc. If there's a search, here's strategies that I want to share with you to respond to that search. One, as I've talked about always, call your personal attorney. Get your attorney on the phone. Generally, you're not going to be able to stop this search, but you can take some actions to try to limit the harm that comes from this search. So you're going to reach out to your attorney. Hopefully your attorney will be able to come on site to your location as soon as possible during the course of that search and be able to help you right on site. Two, you're going to want to obtain the business card of the lead agent and contact information from the prosecutor, because there's going to be a prosecutor assigned to the case at this point, and your personal attorney can reach out to the prosecutor and reach out to the agent to get more information about what they're investigating and what this is about. Three, you want to confirm that the location listed on the search warrant is in fact the location the agents are searching. They are given in the search warrant a specific address that they are allowed to search, a specific location. It could be, the second floor of 10090 Cedar Lane, apartment number 4. And if you're apartment number 5, you want to point out to them they're in the wrong place and get them to go. There are, of course, situations where the agents show up at the wrong place. There's also situations where agents get a warrant and put down the wrong address. Either way, you want to make sure that they're searching the right place that's listed on the search warrant. And you're going to want to get a copy of that search warrant. You're allowed to keep a copy of that document. In addition, it's a good strategy to video record the agents carrying out that search. Just like I said, in terms of an audio interview, that it's good to make an audio recording of an interview with an agent. it's good to make a video recording of agents carrying out the search warrant. So you are allowed to take video. They're at your office, your lab, your home, your warehouse. You're allowed to take video of them carrying out the search, showing what they're searching and where they're searching. Sometimes in those searches, they're going to want to search computers. They're going to have permission to take computers. If you can get them, and this is where it's your personal lawyer might be helpful. If you can get them to copy your computers on site rather than taking your computers and walking away with them, that can help you continue your work. So you can imagine if they take 5 computers from a lab and walk out the door with them, it could be months and months and months before you get your computers back and can continue doing the work. But if instead they can make a permanent duplicate copy of the computer right then and there, then you can continue your work while they do their searches on the computer. So oftentimes, if you can convince them to make copies and give them the time to do that, rather than having them walk out the door with your computer, it's going to be a big help. One of the things that can happen in a search warrant situation is the agents use the search warrant to turn it into a big interview session. So they can use that situation to try to interview everybody on premises. So if you're an office, they might say, hey, while we're here, can we talk to your secretary? Can we talk to your colleague? Can we talk to your subordinate? Can we talk to your partner? And try to interview other people, well, because they're on site while they're conducting the search. You don't want that to happen. So oftentimes what we recommend is that you close your office for the day and you send your employees home. That way, the government, of course, can go ahead and they have a search warrant. They can take and copy whatever it is they're entitled to take and copy. But it avoids all of your employees becoming the subjects of interviews right then and there. If there are particular files that are confidential, that are privileged, particularly attorney-client privileged, it's also useful to point those out to the law enforcement agents doing the search so that they can give those special treatment or not review them. Because even though they have a search warrant, they are still supposed to take care to acknowledge and protect the attorney-client privilege. And so they're not supposed to be searching documents. They can seize the documents that are privileged, but they're supposed to have a different procedure to look at those documents so that they're not invading the privilege. Talk now a moment about strategies to prepare for a possible government search. So I have situations where I'll represent employees. They know that they're involved in an investigation, an individual, and they're concerned that the government may come to their home, to their office, to search for evidence of potential wrongdoing. So first of all, there's 2 scenarios here. One, if you are not aware of an investigation, if you don't know you're being investigated, if you don't know that an investigation is going on at all, you have no obligation to retain evidence of wrongdoing. So if you did something 20 years ago and you happen to have information on your home computer, you're not obligated to keep that information sitting in your home waiting for law enforcement to show up and take your computer. And so you can destroy information before an investigation happens. You can put that away in some other location. You don't have to keep information of records of the worst thing you ever did in your life in order to help others build a case against you. But if you're aware of an investigation, if, for example, your employer has received a subpoena and they've sent out a hold notice about this investigation, or people have come and questioned you about the subject of an investigation. If at that point you destroy information, whether that would be computer information or materials at your home, documents, other records, if you destroy that information, that can be a new and separate crime called obstruction of justice. But again, that does not mean you need to have that information sitting with a bow waiting for law enforcement agents to show up and take away your laptop computer with the important information on it. While you can't destroy that laptop computer, you can move it elsewhere. You can get a safety deposit box and put it in a safety deposit box. You can send it to a friend. You could put it in your vacation home. either, in another state or even overseas. You do not have the obligation to keep, you can give that information to your lawyer so he or she can review it and try to determine how bad that information is for you and what it shows in terms of your potential case. You're not obligated to keep that information sitting in your house, but if an investigation has started, you may not destroy that information. One other point here. There's a concept in the law called consciousness of avoidance, conscious avoidance. You can't pretend that you didn't know of an investigation if you actually knew of it or had reason to know of it. So people will sometimes want to be the ostrich, put their head in the sand and pretend they didn't know of the investigation and then destroy the evidence. If the government can show that you knew of or consciously avoided learning about the investigation and use that to destroy the evidence, that's nevertheless going to become a obstruction of justice crime. And so you don't want to be in a situation where you know of an investigation or should have known or somehow pretending you didn't know and destroyed information based on that false theory. Talked about my number one advice to you. You want to get, for any sort of investigation, you need to have an attorney. That's going to be critical for you to help understand your own strategy on how to deal with such one of these situations. As I talked about, there's the attorney-client privilege, and that protects your confidential communications with your personal attorney. How can you blow the attorney-client privilege? One of the mistakes people do is they communicate with their personal attorney over their company or work email or university email system. So the company email system is generally not confidential because the employer can monitor it. The employer can pull and review their emails if they want to. So if you communicate with your personal attorney on the company email system, that can be information that the government can seize. That's not a confidential communication because it's available to a third party, your employer. And so if requested by the government, they can turn over that information either voluntarily or with a subpoena, they can be required. And so if you're going to communicate with a personal attorney, make sure you don't do it on the company or employer email system. Set up, for example, a separate Gmail account or other email account, a private email system where it's just you and the attorney on those emails that you don't use for any other purpose and that you send from a separate computer. I talked to you before about our smartphone app that I recommend to you. Back in the days when we could get together in person, I would hand you out something, but this is better for the world we live in today. We've developed a smartphone app, and this app was to help in these very kinds of situations we're dealing with here. It provides on your phone instantaneous guidance to deal with a surprise interview, a search warrant being conducted at a home, a document subpoena, and includes on it quick buttons to get to the recording tools. You can press one button on the app and immediately be able to record an audio recording. You can press another button and immediately make a video recording. And those items are saved to your phone. They're not saved to the cloud or anything like that. And of course, it also contains contact information for me and other criminal attorneys. And so you have our cell phone numbers, our emails. And so if, God forbid, there is an emergency, you have this advice right on your phone at 6:30 in the morning if they're coming at the door or whenever that might be, and you can give yourself quick advice while you get the attorney on the phone. Look, these types of interactions we've talked about today with law enforcement or employer investigations, they can be life-changing. What I would suggest is that with knowledge, you're knowledgeable, smart people. Armed with that right knowledge, you can stand up with your rights. You can lessen the harm to you. In 2019, I had FBI agents come to one of my clients' houses and surprised him with questions. He didn't have a lawyer. He talked briefly to them, but ended the conversation. They gave him a subpoena demanding documents. He hired me. In that particular case, we chose never to speak to the FBI agents after understanding the full story of his conduct. We asserted his right not to produce any documents. Ultimately, a number of other people were prosecuted and pled guilty and went to jail. There was sufficient evidence to charge others, but there was insufficient evidence to charge my client, and he was able to continue his life. And the government met their goals of deterrence and all those of making examples of people by prosecuting the others. They didn't need to prosecute my client. And luckily, he was able, because of choices he made, to continue in that situation. I'm at the end now, a minute over. I appreciate the opportunity to speak today. I recommend that you do download our app for free from the Apple Store or Google Play by searching for M&M Defend. You see the name up there. Call or email me if I can ever be of service to you. I'm here to be a resource. If you'd like a PDF copy version of these slides as a resource, we're going to put them at the CAS forum site. But I'm also happy to email you a PDF version of this presentation from tonight. We're now going to go to the questions. Thank you again for having me. It was a real honor.